Ready, start. Rajasthan High Court Dictation. I have heard learned counsel for the parties and gone through the record stove, as there is no argument raised on behalf of learned counsel for the appellant as regards the issue of execution of the agreement in question. Therefore, the same is not required to be dealt with in this case as such. Findings recorded by both the courts below in this regard has to remain undisturbed, consequently upheld. Stop. Now the only question which the accuracy and integrity of this document survives in the present appeal is about the readiness and willingness of the respondent plaintiff so as to perform his part of the agreement in question. Stop. Para. Readiness and willingness has been expounded upon by the Honorable Supreme Court in judgments titled as His Holiness Acharya Swami Ganesh Das Ji versus Sitaram Thapar AIR 1996 SC 2095, and it has been held that readiness means the capacity of the plaintiff to perform his part of contract, which includes his financial position to pay the purchase price and the willingness to perform his part of the contract, which relates to his conduct. Stop. There is a distinction between readiness to perform the contract and willingness to perform the contract. Stop. By readiness may be meant the capacity of the plaintiff to perform the contract, which includes his financial position to pay the purchase price. Stop. For determining his willingness to perform his part of the contract, the conduct has to be properly scrutinized. Stop. There is no documentary proof. Stop. Over. Next dictation start in 5 seconds. There is a distinction between readiness to perform the contract and willingness to perform the contract. Stop. By readiness may be meant the capacity of the plaintiff to perform the contract, which includes his financial position to pay the purchase price. Stop. For determining his willingness to perform his part of the contract, the conduct has to be properly scrutinized. Stop. There is no documentary proof that the plaintiff had ever funds to pay the balance of consideration. Stop. Assuming that he had the funds, he has to prove his willingness to perform his part of the contract. Stop. According to the terms of the agreement, the plaintiff was to supply the draft sale deed to the defendant within 7 days of the execution of the agreement by 27 February 1975. Stop. The draft sale deed was not returned after being duly approved by the petitioner. Stop. The factum of readiness and willingness to perform plaintiff's part of the contract is to be adjudged with reference to the conduct of the party and the attending circumstances. Stop. The court may infer from the facts and circumstances whether the plaintiff was ready and willing to perform his part of the contract. Stop. The words ready and willing imply that the person was prepared to carry out the terms of the contract. Stop. The distinction between readiness and willingness is that the former refers to financial capacity and the latter to the conduct of the plaintiff wanting performance stop. Generally, readiness is backed by willingness stop over. Next, dictation. Start in 5 seconds. This is an appeal filed by the claimants challenging the award passed by the Motor Accidents Claims Tribunal Chandigarh within bracket hereinafter referred to as the tribunal bracket on the ground of insufficiency of compensation awarded to them on account of death of Ashok Kumar Stoke. The facts of the case as mentioned in the award of the tribunal are that on 1 August 2009, Ashok Kumar was pillion riding a scooter bearing registration number CHT114 driven by Mahendra Singh Jat Stoke. They were going to Manni Majra after closing their shops situated in Sector 8B Chandigarh Stoke. When they reached on the road dividing sectors 7 and 8 and turned their scooter towards left side. The car bearing registration number SP33B 3004 hereinafter referred as offending vehicle driven by respondent number 1 rashly and negligently came from backside from the Madhya Marg Chandigarh and hit the scooter stop. As a result thereof, the persons on the scooter fell on the road and received head injury along with other multiple injuries. Stop. They were taken to the PGI Chandigarh. However, Ashok Kumar succumbed to the injuries at PGI Chandigarh on 5 August 2009 Stoke. In view of this, the claimants filed a claim petition claiming the negligence on the part of respondent number 1 Stoke. It was pleaded that deceased Ashok Kumar was 50 years of age Stoke. He was having a shop of vegetable in Sector 8 Chandigarh Stoke. His income was claimed to be rupees 20,000 per month stroke. Accordingly, the compensation was claimed by the claimants who are the widow, two daughters and one son of deceased Ashok Kumar Stoke. Para upon notice driver come owner of the offending vehicle oblique respondent number 1 filed written statement pleading that no accident was caused by him Stoke. It was further denied that the offending car was being driven in a rash and negligent manner Stoke. Respondent number 2 in the claim petition, the insurance company also filed a separate written statement taking routine preliminary objection and claiming that the driver of the offending car was not holding a valid driving license at the time of accident stop. On merit, it was further pleaded that no accident as alleged had taken place stop. Still, further, it was claimed that no intimation regarding the accident was given to the insurance company stop. After hearing the parties, the tribunal awarded an amount of rupees 7,12,000 as total compensation stop. To arrive at this figure, the tribunal assessed the national income of the deceased at rupees 6,000 per month. So, the tribunal held that though it has come on record that the deceased was a licensed vegetable vendor having a permanent shop in Sector 8, Chandigarh, stop over. Our third and last dictation will start in 10 seconds. Ready for the dictation? Ready, start. On the other hand, learned counsel for the respondent oblique insurance company submits that income has rightly been taken by the tribunal at rupees 6,000 per month since no documentary evidence has been led by the claimant's store. It is his submission that no record of income tax return of the deceased had been placed on record, although he was having a PAN card stock. Therefore, the tribunal has rightly assessed the income stock. On the point of future prospects, learned counsel submits that the matter has been considered by the Honorable Supreme Court in the judgment of National Insurance Company Limited within bracket Supra had as per the judgment the benefit of future prospects can be granted only in case of established income stock. Therefore, learned counsel submits that since the income has not been proved on record by leading documentary evidence, therefore no benefit of future prospects can be granted in the present case. Stop. It is his further submission that the compensation on account of funeral expenses and loss of consortium has also been rightly granted by the tribunal and the same need not be enhanced. So, learned counsel further submits that the multiplier in the present case has to be less than 13 because the deceased had crossed the age of 50 stroke. Para, having heard the learned counsel for the parties and perusing the record with their able assistance, this court is of the considered opinion that the arguments advanced by learned counsel for the appellants deserve to be sustained and the compensation granted to the claimants deserves to be enhanced. Stop. So far as income of the deceased is concerned, the tribunal has taken the income to be rupees 6,000 per month, although the claimants had claimed the same to be rupees 20,000 per month stock. Since the documentary evidence in the form of business records has not been placed on record to substantiate the claim of income of rupees 20,000 per month, therefore this figure cannot be accepted by the court on its face value stock. Hence, the income cannot be taken to be rupees 20,000 per month as claimed by the appellant's store. However, it is proved on record that deceased was not an ordinary labor store. He was having his own shop in main market of Sector 8 Chandigarh store. It has also been proved on record that he was having a license of vegetable vendor store. Still further, it has come on record that on that fateful day also he was returning from the same shop to his residence after ending the business day store. Therefore, in view of the circumstances, the income of the deceased cannot be taken to be less than at least rupees 350 per day stock over. आप इन तीनों एक्सरसाइज को रिवाइज करें, उसको पढ़ें बार बार, जो वर्ड आपसे नहीं बनाया उसको सर्कल करके उसकी प्रैक्टिस करें और आगे भी प्रैक्टिस करते रहें। कल भी इसी टाइम ये सेशन स्टार्ट होगा, तो आप सब इसको जॉइन कर लें। थैंक यू।